Oil and gas contracts are complex. They involve lots of money and complicated operations. Sometimes parties disagree on what the contract means. This can lead to disputes. Arbitration is a way to resolve these disputes outside of court. Arbitration is like a private court. The parties choose an arbitrator or a group of arbitrators to decide the case. This is different from going to court, where a judge is appointed. Arbitration is important in the oil and gas sector for several reasons. It is usually faster and less expensive than going to court. It is also more private, which can be important for companies that don't want to air their dirty laundry in public. Finally, arbitration is often seen as more neutral than going to court, especially in cross-border disputes. This is because the parties can choose an arbitrator from a neutral country. Oil and gas contracts can be very complex. They cover a lot of different things like exploration, production, transportation, and sale of oil and gas. This complexity can lead to many types of disputes. Some common disputes in oil and gas contracts include disputes over the interpretation of the contract. For example, the parties may disagree on the meaning of a particular clause. Disputes over the performance of the contract. For example, one party may allege that the other party has breached the contract. Disputes over payment. For example, one party may allege that the other party has not paid the agreed-upon amount. To ensure effective dispute resolution, it's essential to have a clear and comprehensive arbitration clause in the contract. Key elements of a robust arbitration clause include the seat of arbitration, which is the place where the arbitration will take place, the language of arbitration, the number of arbitrators, the method for appointing arbitrators, the rules of arbitration that will govern the proceedings. The arbitration process is similar to a court proceeding, but it is more flexible and less formal. The process typically begins with one party filing a notice of arbitration with the other party and the arbitration tribunal. Once the tribunal is constituted, it will hold a preliminary hearing to set the ground rules for the arbitration. The parties will then exchange written submissions which set out their respective cases. After the exchange of written submissions, the tribunal will hold a hearing. This is an opportunity for the parties to present their evidence and arguments in person. The tribunal will then issue an award which is binding on the parties. Evidence is crucial in arbitration. It helps the tribunal decide the outcome of the dispute. Evidence can take many forms, including documents, witness testimony, and expert reports. Expert witnesses play a vital role in oil and gas arbitrations. These experts have specialized knowledge of the industry and can provide the tribunal with their opinion on technical issues. Oil and gas projects often involve parties from different countries. This can make dispute resolution more challenging. International arbitration provides a neutral forum for resolving disputes involving parties from different countries. Several international conventions and rules govern international arbitration, such as the New York Convention, which makes it easier to enforce arbitral awards across borders. Arbitration offers several advantages for resolving oil and gas disputes. It is typically faster, less expensive, and more private than court proceedings. Additionally, arbitration offers flexibility, neutrality, and expertise. The parties can tailor the process to their specific needs and choose arbitrators with relevant industry knowledge. The international enforceability of arbitral awards ensures that parties can enforce their rights even if the other party is located in a different country. Overall, arbitration provides an effective and efficient means of resolving complex oil and gas disputes, fostering a stable and predictable business environment for the industry.